Okay, folks, I know that we are all tired and exhausted, but we really need to continue. Okay, so you remember what was the last topic before the previous session, and we said that we have these provisions 2 and 5 of the CEDAW, of the Convention on the Elimination of All Forms of Discrimination Against Women, which was a good basis for the CEDAW, for the committee, to relying on these provisions to firstly focus on this issue, the issue of gender bias. And what we covered previously with Professor Tanasi Marinkovic is one interesting question and also decision of the European Court of Human Rights, where we can say that maybe the court was also blind, one international court, but now we will refer to some good practices or good practices of international bodies, primarily CEDAW and the European Court of Human Rights, where we will also see the national courts, national judges erred in deciding in some very interesting cases, and you will see what these cases are about. The first case that I would like to draw your attention is the case which was decided. I'm sorry, just to, again, it was the case against the Philippines. And what happened here was that the applicant was raped. And she was raped by an older partner in her law firm, and they went to some dinner, which was a professional meeting with some colleagues, and then on the way back, she was raped. And what happened in this case is, as you can see, that the court trial lasted for 8 years, so it was a long-lasting trial. And the judge, the national judge in the Philippines, did not find that she proved that this was the case of rape. And basically what happened was that in this case we had an impunity, for what happened. How it happened that the court did not find that this man was guilty or responsible for the rape. The issue was that the national court relied on some common myths in rape cases. And here are those common myths. So the first one is that women should physically resist sexual assault at every opportunity. So this is what we usually hear when we have victims of rape, that no matter what, no matter how old the victim has and how physically that victim is fit in compared to the perpetrator, she always need and should resist. Another common myth was that women are inherently untruthful and thus likely to fabricate allegations of rape. And this is also something common that we usually hear, and especially when we have cases of rape, you know that sometimes in those reports we find in some social media comments that women usually they have false reports on rape cases, or sometimes that they even provoke the rape. And another very interesting common myth in this case was that older men lack sexual prowess, because he was like 60 at the time when he committed this act of rape. It was enough for the court to find that basically it's more likely that it did not happen. And then the last myth was that perpetrators of rape are usually strangers. So in this case, she was in good terms with her older colleague. She knew him, and relying on all these 4 common myths, the national judge concluded that she was not raped. So what was the decision in this case? Of course, first, the committee found that the state erred in having such a long trial and also coming to this conclusion. But we have some extracts from the decision which for the first time opened the floor for gender stereotypes by the judiciary. So what the committee said? It said that the assessment of the credibility of the author's version of event was influenced by a number of stereotypes. The author in this situation not having followed what was expected from a rational and ideal victim, or what the judge considered to be the rational and ideal response of a woman in a rape situation. And here, the committee underlined that stereotyping affects women's right to a fair and just trial, and that the judiciary must take caution not to create inflexible standards of what women or girls should be or have done when confronted with a situation of rape based merely on preconceived notions of what defines a rape victim. So here, for the first time, not only that the issue of gender stereotypes was clearly underlined by the committee, but also what we find is that if we do not combat those stereotypes and if we allow them to influence the case, especially criminal case, then we will have a problem, or it will influence the right to fair trial and also access to justice for some women. Another case which was interesting here comes from the employment area, and it was RKB versus Turkey. What happened in this case was that we had a female. She used to work in a salon, in a hairdresser salon, and she was married. She started to hang out with another male colleague he was also married. So on some breaks, they went out to have dinner or lunch together, to have a coffee break, and then people started to gossip that they are in possible relationship. What was problematic is that, first of all, clients started to gossip, and then that gossip spread over their colleagues. And what the employer or the owner of this salon decided is to fire her, but not him. And this is what she challenged in Turkish courts. She said that, first of all, they were not in a relationship, that she is married and he was married, but in a case that really some gossip happened, and that employer decided that due to that, because some clients, they said that they will not come to that salon because the morality is not so high. So that was the issue here. Then she said, okay, if the employer thought that it really influences the business, why he also didn't fire him as well as her. And Turkish court in this case basically did not take this perspective into account, and they thought that it is on the employer to decide what can ruin his business, and that this is not a case of stereotypes. So what the committee in this case found is that the court proceedings were based on the stereotyped perception of the gravity of extramarital affairs by women, that extramarital relationships were acceptable for men and not for women, and that only women had the duty to refrain from even the slightest offense against morality. And then the committee found that gender stereotypes are perpetrated through a variety of means in institutions, including laws and legal systems, and that they can be perpetuated by state actors in all branches and levels of government and by private actors. The Turkish lower instance court has clearly allowed its reasoning based on law and facts to be influenced by stereotypes. The Court of Cassation failed to address the gender aspects and has perpetuated gender stereotypes about the role of women and men, with it being accepted for the latter to have extramarital affairs. So here, the committee even went further, saying that stereotypes can be found in different institutions, including the judiciary, which was clear. And also what we find here, that all levels of Turkish courts found that this is not a case of discrimination, although it was clear that the decision of the employer was based on the stereotype notion of what is accepted for men and women when they are married, and did not take that into account. Another case, González Carreño versus Spain, is interesting because here, and we have some cases which are really emotional cases, and they deal with domestic violence. In this case, basically, we had a separation of two partners, and their little daughter, who was, when they separated, it was decided by the court that the father should remain visitation rights. However, he claimed that he will kill her partner and the daughter. The court did not take that into account, thinking that it is only his frustration and that he is just threatening to his ex-partner. But unfortunately, what happened is that he committed suicide, also killing a 3-year-old daughter at that time. And here again, what we see is that the committee again not wanting to influence that visitation rights are really important, and that for all child, it's after the separation of parents, it's important to be in a contact, of course. But here we really had a clear example of real threat to the life of the ex-partner and also the daughter of partners. And what the court found, what the committee found is that all of these elements reflect a pattern of action which responds to a stereotyped conception of visiting rights based on formal equality, which in the present case gave clear advantages to the father despite his abusive conduct and minimized the situation of mother and daughter as victims of violence, placing them in a vulnerable position. And also what the committee found is that, again, repeated that it can influence the right to fair trials and also access to justice. And what you can see in this paragraph 9.7, the committee find that stereotypes affected the right of women to an impartial judicial process, and that the judiciary should not apply inflexible standards based on preconceived notions about what constitute domestic violence. So again, we have the same or pretty much the same situation. So as we marked now, we have a case of rape, so criminal law. We also have employment when it was visible, and now we have domestic violence. And in all three cases, we have either some common or ideal perception of what should be, and also we have this inflexible notion when we want to really push formal equality, thinking that this is in the best interest of all actors or parties before the court. This was also again named in another case, J.I. versus Finland. And here again we have a domestic violence. We have too many examples of that domestic violence, which was not only physical but was also emotional, and it continued. And in this case, also the question was to whom the rights will be belong. I mean, and how the visiting rights will be visitation rights. Will be decided among partners. And here, the committee found a very similar, it reached a very similar decision, but what is a plus in this case is that the committee found that stereotyping can cause judges to misinterpret and misapply laws. So it's not only that sometimes they can be inflexible, but their interpretation of the law can be not objective, as we discussed, but wrong, and that it can lead to a wrong result, which in this case, as in a previous one, had very serious consequences. So these are just few examples, and we also have some other decisions of the committee on this matter, and it also seems that lately committee really focuses on the issue of stereotypes, and we can say that today it's a leading international body discussing how it can influence the court and the process. I already mentioned that when we take into account the European Court of Human Rights, we have pretty extensive jurisprudence on gender equality, and different issues were discussed before the court. However, when it comes to the stereotyping and stereotypes, we don't have so many cases where this issue was underlined. The first case in which the role of stereotypes, not by judges, but the role of stereotypes in general was invoked, is this very famous case, Konstantin Markin versus Russia, and I'm sure that some of you are familiar with this case. This case deals with parental rights and the right to have this right under the same footing or in equal terms with mothers or women. We had the applicant, who is a male. He requested 3 years of parental leave because his wife left him. When they got a third child, she decided to leave the family, and he was a single parent, so he really wanted to have parental rights on the same footing as his female colleagues, and he was refused. He got, I think, only 1 year. So he complained, and courts in Russia thought that for him it's enough that he still has parental rights and that he should not claim this right under the same conditions. And here, as you can see, this is the judgment of the Grand Chamber, which means that also this issue was very much discussed before the European Court of Human Rights. And we also have another case which was decided some 12 years before this case, when the issue of parental rights in one case against Austria was raised. And Professor Marinkovic mentioned the margin of appreciation. At that time, the court found that this is the issue which falls under the margin of appreciation of each state, but then 12 years later, the court decided to underline that this issue needs to be improved. That in 1998, we could say that we can make a difference between men and women in this respect, but 12 years later, that we really need to underline what is behind the policy of states not to acknowledge and not to recognize this right under the same footing. And in this judgment, this is why I will again read, because it's extremely important to focus on what the court found. The court said that the references to traditions, general assumptions, or prevailing social attitudes in a particular country are insufficient justification for a difference in treatment on grounds of sex. And what also the court found is that and the court agrees with the applicant that such difference has the effect of perpetuating gender stereotypes and is disadvantageous. Advantageous both to women's careers and to men's family life. So what we have here is that the court did not found that the issue of stereotypes was in some court judgment. But the presumption or biases which are prevailing in a society, and if we rely on them, can really be very detrimental, not only for women's rights, but also for men's rights. And this part of the judgment is cited in many articles dealing with this issue, and this is really the leading principle now in cases that deals with gender equality. However, the first case where the court found stereotypes in court decisions was another case, and I'm not sure whether some of you are also familiar with this case, but now it's really a landmark case. This is Carvalho Pinto versus Portugal. And what basically happened in this case is that we had the applicant. She is a female. At the time, she was around 54. She went through gynecological surgery, which went wrong. Due to that negligence, basically she suffered a lot. Not only that she had bleedings and also huge pain, but she couldn't have sexual intercourse with her partner, with her husband, and also she couldn't work. And she wanted to claim compensation, and this is what she did. And here, in this case, what we have is that the Supreme Administrative Court of Portugal confirmed the decision that she should be compensated. So it was already awarded by a first instance court. But what the issue was here, that the Supreme Court diminished the amount of compensation, relying that she was already 50 years old at the time of the surgery and had 2 children. That is an age when sexuality is not as important as in younger years. Its significance diminishing with age, and the fact that she probably only needed to take care of her husband, considering the age of her children. So can you imagine that it was a part of the reasoning of the court decision, and not some lower instance decision, but it was a Supreme Administrative Court. And here, relying on these stereotypes about the sexuality of women and their need to work at this age, What was really important is that, as the court found, the assumption reflected a traditional idea of female sexuality as being essentially linked to childbearing purposes, and thus ignored its physical and psychological relevance for the self-fulfillment of women as people. So this is what the court found. And the reasoning of the European Court was that here the court made a general assumption without attempting to look at its validity in the concrete case. Also, what was really interesting in this case is that for the first time, we have by the European Court of Human Rights focus on two grounds. Because here, what was basically a problem is the sex of this applicant and also her age, because she was older, so she was after 50. So the court found that we have intersectionality in this case, that we have two grounds for discrimination. And it was really important because this was the first time that it was so clearly underlined by the court. What was also found in this case, and now we come to why this feminist approach is really important, because now we can say, okay, this is the stereotype, this is a bias by judges, so she was not compensated as she should be. However, the problem here was that the applicant found some previous judgments by the same court, by the Supreme Administrative Court in Portugal. And here we had two male patients, which also, they didn't went through same surgery, but what happened in their case, they also were exposed to medical malpractice. And one of them was 55, another one was 59, so they were even older than the female applicant. And now let me focus on the judgments in these cases. Here, the same court found that the fact that the men could no longer have normal sexual relations had affected their self-esteem and resulted in a tremendous shock and strong mental shock. So it was a totally reversible approach to the loss of sexual activity for these two applicants, and in these two cases, the amount of compensation was much higher than in the case of the applicant. So this is why, in the court's view, as you can find, those considerations, so taking into account all these elements, show the prejudices prevailing amongst the judiciary in Portugal. So it was for the first time by the European Court of Human Rights to find exactly that it was a part of court bias. And we have another case, a very recent case, that I wanted to show you today. This is GL versus Italy. Here we have a young woman. She was, can we hear some voices? I'm just sorry for a second. Okay, sorry, we can continue. So what happened in her case is that she was, but I really urge you, if you're interested in this topic, to go and read this judgment, because it's extremely interesting. But what happened in her case, she was outside, she was drinking with some of her colleagues from the faculty and also friends of her colleagues. And what happened after the party that they went together, that she was raped, and she was raped by 7 men in her case. And unfortunately, due to all the facts of the case, we have something which we call a secondary victimization. In this case, the investigators, police, and prosecutors, they questioned her in a very inappropriate manner, and not only that she repeated on so many occasions what happened, but also that the trial was very emotional to her, because the judge was also biased, and he allowed some very questions which related to her past, to how she is dressed, to how she behaves, to the issue that she was also drunk and that she had very free style in relationships with others. And unfortunately, on the appeal, the court acknowledged that and they included in the judgment all these elements about her sexuality, about her personal life, and as you can see, what's a part of the judgment, that she was fragile, vulgar, and lascivious, that her appearance was as such. In this case, the European Court of Human Rights was also clear that what happened in her case is unacceptable from the perspective of the European Convention of Human Rights, that first of all, the issue of her credibility was very problematic, because investigators and also the trial did not give stand to her testifying that she was exposed to secondary victimization, as she constantly needed to undergo what happened to her and to reveal it in front of others in a very humiliating and also offending environment. And here the court underlined that judges' freedom of expression in decisions is limited. They cannot reproduce sexist stereotypes, reduce sexist violence, and blame women. This is secondary victimization. And it's a very important finding. And as I said, we don't have time to go into the detail, but please, if you have time, go and read this decision, because it will give you in more detail how this case was basically terrifying, really, from the position of victims. And another, and finally the last case is the latest one. It is an interesting one. It is called Krstić versus Croatia, so it comes from the regional country. And here we have a woman. She underwent fertilization. She did it 10 days before she entered the contract with a new employer. She did not say that she underwent this procedure because she already did it. It was not successful, and she didn't want to reveal it. But then eventually she got pregnant. It was successful. And then what happened in this case, the employer thought that she was not open, that she did not say something that the employer needed to know when they concluded the contract, and that this contract is void. And this is what happened. She couldn't get any let's say medical insurance, because the employer decided to cancel the contract. And she complained about her status, about this situation, but all authorities in Croatia thought that the employer is right. So what here the European Court of Human Rights found is that, first of all, the pregnancy should not be taken as a false behavior, and then also she had right not to reveal something which is a part of her personal information, and also part of her status, especially family one. And here the court expressed concern over the overtone of the domestic authorities' conclusion, which implied that women should not work or seek employment during pregnancy or opportunities to do so. This leads to gender stereotypes that pose a serious obstacle to achieving substantive gender equality. So here the court found that what happened to her should not be happening, and that authorities were basically they supported the view of the employer that she did something false when she did not reveal that she undergone this treatment. So here we have basically the conclusion of what we learned from these cases. First of all, what we see is that stereotypes compromise the impartiality of judges' decisions. So we return to the beginning of our presentation today saying, is it objective approach? No, it's not objective approach, because we are not taking into account something which is really important, which is of crucial importance for the case in order to find to the right conclusion. Then a particular problematic is the interpretation of judges' interpretation of ideal victims, or in a criminal law we have specific problem that we have that notion of ideal or perfect victim. then especially it influences the issue of credibility that we especially seen in this case versus Italy. We've seen in this case versus the Philippines that it can lead to impunity. That due to all these factors, the result of the case could be that someone who committed some serious crime can be left and without any responsibility and any consequences for that. And finally, it comes to the conclusion when we spoke about all these, let's say, measures that we should do. If we establish mechanisms for the protection, which is extremely important in the area of equality and gender discrimination, then if we have cases as such, if our victims undergo secondary victimization, if the results of the case are not appropriate and effective, then we will have another consequence, and this is to refrain victims from seeking protection. So finally, I have some case study, but we don't have a time for that. I would like to conclude, but maybe just a short discussion with all of you on this. So what we can do. So we are all legal professionals. Some will become legal professionals. But what we can do to change the situation, as these are we grabbed only through some very few cases which came to international bodies, Committee and European Court of Human Rights. But you can guess how many cases of such we have, not only in Serbia, but worldwide. So what we can do to prevent cases in which judges rely on biases, and what is here problematic. In some instances or in some legal systems, we can have reasoning of the court which is much longer than, for example, in Serbia. And there we can find many stereotypical sentences on which the court relied in bringing decision. But in some cases, like in Serbia, we have decisions which more or less they rely on the legislation, and then briefly repeat facts of the case, and then we have a conclusion which is usually short, sometimes not even in direct connection with the legislation and facts of the case. But what we do not see from that decision, from the rationale of the decision, is what was the main reasoning that was behind the court to decide. And it's, let's say, hidden in majority of cases. But what we should do? Do you have any proposal how to approach? Of course, the first issue is what we also said, awareness raising. It was very brave on the part of the CEDAW also to bring this issue into the table. And we also have one general comment adopted by the committee when this issue was really underlined. So for many years, we did not deal with judiciary and with biases and the role of biases in judiciary. So the first step is to be aware of the problem and where to continue. Any proposal to what we can do? Marko.
I marked some things here. So first we are speaking about biases, and I was really amazed how even I am working in this field and I am also biased. So I can't imagine other people who are not working closely to this topic. We mentioned ageism, credibility, women's rights, women's employment rights. We mentioned this gender-based violence. And also we mentioned something about police investigators that are doing this primarily investigation when these cases came around. And I think that because we are working with the police, and it is important for police officers to be educated on this subject, because when they investigating the first and interviewing the victims, they have to be gender sensitive, and they are in most of the cases are not. So I think that is also maybe some as we, for example, have in the judiciary some special bodies for corruption. In police, we should have some gender-sensitive approach and educate police officers how to approach when these problems arise.
Then, if I understood, the first measure that you delegate today is basically training of police officers. Good. Nemanja?
Might sound funny, but higher salaries for judges, because they're not motivated enough. They believe their job isn't well spotted, and also.
Okay, can I interrupt you here?
Yes.
Do you think really that that this measure is relevant here?
Maybe not in the first plan. Yes, but I just add that judges, when they decide, they will choose the path with least path with least. Yes, thank you.
Okay, because I draw your attention to these judgments that we discussed. For example, in Portugal, and it's really also common that sometimes the lower instance court can be more open than the higher courts. And what we know is the highest court in each country. I mean, the judges of highest courts, they have very nice and decent salaries. So is it really a question of salary, or what Marko suggested, we really need to concentrate on awareness raising and training? So he delegated police officers, but I think that we can also say that we should also train judges. Sreten.
We can explore jurisprudence and analyzing it and bring it to light if we see some of the cases of discrimination, gender bias in those particular cases.
Okay, good. Anna?
Okay, I would like to what colleague is saying. I would say that this may influence independence of judges, and I agree that high salaries maybe can influence that. But when we talk about stereotypes, I think that apart from training of judges, because we talk about stereotypes, but we have to be aware that sometimes successful people and more educated people are even not aware of their stereotypes, and they think that they're well educated, they know everything. So we have to try to change that by raising awareness, training, but also maybe monitoring judgments and trying. And I also like a feminist judgment project when it's trying to rewrite all the judgments in gender-sensitive manner. So I think that this can also influence and start from, of course, raising awareness among academics, but also trying to give guidelines through monitoring and scanning all the judgments from the courts.
Okay, thank you, Anna. Mina?
Maybe to form a body with women to basically be some kind of control buffer, because when talking about judges and police officer or anyone who's older, I am worried that even though we are trying to raise awareness and even though we are trying to educate them, they grow up and form their opinion. They are formed people basically, and they form their opinion in a total different time. So I am afraid that even though we are trying to educate them, it is not going to have an effect because they're already formed. So it's not like they're children or they're young, so we can influence them. So I think that maybe some effective solution would be to have women to just be there for other women, to not just as a support, but to help them and guide them through the process.
It's a good point. Mila?
Well, I don't have any new solution. I just have one comment that in Serbia, majority of judges are women, like 70% of them. So just at first glance, it should be easier to train our female judges to be tolerant and understand the women victims. So as a start, it's just a good start. So, but we're not sure of the end, but just for the beginning, it can help.
Good. Sofia?
Well, I would like to draw on what our colleague said about higher salaries of judges, and while I do not think it should be the primary line of action, it might have some benefits, because when we see that the lower level judges are not paid very much, then the highest educated lawyers that are legal professionals are not really motivated to go into the judiciary branch. So what we get in the higher level judiciary organs is not really the best that we have. So in that regard, maybe it would be better to have higher salaries in the lower levels. And also you mentioned the problem of the elaboration of arguments in the decisions of our courts not being really long and detailed. So maybe higher salaries would, in a longer term solution, be a good course of action to motivate those judges to work on that. So if they are, shall we say, pressured to make elaborations that are detailed, maybe they will see eventually that there are some holes in their arguments, that something is not right. So not really instant solution, but in the long term, maybe it's something.
Now salary makes sense. Okay, good. Marco?
Yes, I want to follow up on what colleague says about gender-sensitive language, and I think it is important, and it's a heated topic, and it's in the discussion right now, how the organi javnih vlasti. Public authorities and media, how they should implement the gender-sensitive language. It's a complex issue, but I think that would also add the raising awareness of how women are important in the society, and also the colleague mentioned special boards of women. And in regard of what I said earlier about this training of police officers, also forming a specialized bodies within the police that are strictly specialized dealing with problems, for example, domestic violence.
Good. We also have Larissa. Larissa, please, the floor is yours.
Thank you. Okay, so I also wanted to reflect on this money issue, because in the first lecture I noted down corruption issue. So in the judiciary or whatever, because these non-transparent judicial decisions are basically the floor for the corruption. So it's not transparent. We don't see the reasoning behind the decisions. So I think that's generally a problem in our judiciary system. When it comes to training and gender mainstreaming, I would add lawyers also to be trained in gender mainstreaming, because when the discrimination happens, the lawyers are the one who will tell that person potential litigant is, do they have the case or they don't have the case. It's very particularly sensitive in these fields when it's indirect discrimination or even mobbing, which is very difficult to go into and to, how should I say, to prove. Another thing, when it comes to this forming a group, I also noted down forming a group of lawyers who would be specialized especially for this kind of discrimination, or gender lawyers, or however that body would be defined, so that people who are victims would easily find them and know which body they could, which like chamber of the lawyers they could appeal to or first go to. And also when it comes to this, I would place this intersectionality issue, which is class and economic issue, but from the side of the victims of discrimination. Because, okay, maybe it wasn't transparent in the cases that you showed, but from the cases I know in Serbia, most of the victims are deprived of economic means. And most of the women from sexual violence and family violence are deprived completely of that. And because they don't have funds to enter the court procedures, and even to have a team of lawyers, they never go into police. They never even try to go into trial, because all people know that going into court is economically draining, and people don't have that. I know that several NGOs like this, because I follow them, they give some kind of even money support for the process. I'm not sure, is it like mobbing, but specific types of mobbing in jobs, but they're very specialized for some types of mobbing. And so I think that also this kind of organizations that could provide means for the court would be helpful. And I also think that discrimination cases in Serbia need a team of lawyers to be gathered, and we need lawyers in the position of high authority already established and credible in this society and in the law chamber to be the one who will lead this fight, because it's very important also to start from the top. So that is
Okay. Okay, Larissa, thank you also for your comments. We also have Diana, who said that she cannot discuss this issue as she is not a lawyer, but of course we now just give some reasonable measures, some measures which seems to be reasonable in this case, and we mentioned also some boundaries that we have in our judiciary at the moment. Some of them are directly or maybe more indirectly linked with what we discussed tonight. One of the measures that we did not mention, Marco said training of police, but not only training of police officers, prosecutors need to be trained, not only judges, but also, for example, expert witnesses. They also need to be trained, so all actors which take part, all parties in the process. Another issue which is very interesting is access to judgments, because we don't have mostly we don't have access to judgments, and especially in this area. And also to discuss good practices, because we also have some judgments where judges took into account feminist approach, and although they are rare, they exist, and we should also talk about them. We need to conclude, and in that regard, I would just like to finish this presentation with some news, and this is that several months ago, this one regional network of judges who are interested in gender equality was established, so on a regional level. And next week, they will gather in Belgrade with judges of the European Court of Human Rights in the first visit of the President of the European Court of Human Rights. And yesterday you heard that she is a first female president of the court. So they will discuss the jurisprudence, the judgments of the European Court of Human Rights, and they will also discuss their own judgments and obstacles in applying gender equality principle. So this is a good starting point, and some of you named this peer-to-peer also support. It's very important, and now we will build let's say a list of judges who will have this feminist approach, and hopefully it will influence other judges to join the network and also to apply this approach in their judgments. So thank you so much. Nemanja, you wanted to say something? I'm sorry.
Yes, I'll be quick. So if our judgments are in our legal system are public, why wouldn't we live stream some cases? It wouldn't be illegal, I guess.
Now you open the floor to totally another issue, and Professor Marinkovic can also discuss with you for I think hours, but forget about this because I think that we are all tired and we need a break. So thank you so much for your participation. Thank you so much for your patience. See you tomorrow at 10. So we start, and please be here on time. So thank you once again.